Hi everyone, Keith here. Hey, I wanted to put a quick video out to let everybody know got a case coming up tomorrow that I'm helping a friend with, and if you look through my post, you'll see a while back here I posted what was it? A required admissions, and it was a list of a bunch of questions that are structured to come out with facts that are true rather than just facts pretended by the prosecution. And this is why it's important when they read off the nature and cause of the charges to question those individually. Ask them what the nature of the charge is and what the cause of the charge is, what the nature of the action and what the cause of the action is. When you ask these pertinent questions and it leads to the truth, then it helps them understand that they need to just submit and lay off and not pursue these matters any further. They're void, period. It's not a matter of dismissing them. They're just going to avoid them. This is stuff that needs to be brought in before the arraignment so that they understand that once that arraignment comes, they don't provide a security to start trading on the global market. Once they provide a security that starts trading on the global market, they've committed fraud. They've committed fraud already. So understand this. Anyway, I want to go over this real quick. We've got the court appointment tomorrow. They actually scheduled 2 appointments, one for 10 o'clock in the morning for order for a pro se, in which he never filed anything pro se. We just admitted documents with this required admissions, and now they've appointed a public defender because he did sign paperwork, financial statements, but he's rescinding any kind of signature saying that he is contractually bound because he did so unwittingly, unknowingly, and unintentionally, and gaining knowledge that he's given jurisdiction to them. By doing so, he's rescinding that signature. That is not his intent. His intent is to have his Sixth Amendment right to the support of counsel. Support of counsel. Not a lawyer, not attorney. No license required. Nothing. And so, anyway, we're going to be going in tomorrow for 10 o'clock for the pro se thing. And while we're there, we're going to see if we can have them go ahead and do the arraignment that is scheduled at 1:30. 2 appointments one day. And, of course, we're submitting paperwork as a special visitation and not to be construed in any way, shape, or form as a general appearance of any sort. So anyway, we've got this document, which is the one that we filed already. That's the admissions. And then on that admissions, we filed a second notice. This one here was entered on the 16th of October at 11:25 a.m. And then the second notice was given on the 6th of November at approximately 3:30. And then this is our notice of special visitation that we're going to present tomorrow. And this is the one that's got the 2 questions about nature of the action and cause of the action. Those are 2 important questions to ask them so that you can have an understanding of the nature and cause. If you cannot be fully informed, then you cannot make an informed plea. You cannot plead guilty to charges without understanding that they don't have jurisdiction. Those 2 questions will clear that up. If they refuse to answer them, they are participating in that fraud. Particularly when you're in that courtroom by yourself and there's an administrator on the bench and no one else but you. There's no prosecutor. There's no officer that made the accusation. There's no court recorder. That's why you make sure that these proceedings are on and for the record, for your own protection and for the accountability for all other participants acting in their capacity that gives them standing and status in the jurisdiction they are claiming. And they have to claim personal jurisdiction in order to have that jurisdiction. Otherwise, they are implying that you've given them consent, or presuming that you've given them consent because you've implied it somewhere. One or the other. We have to make the discrepancy. We have to discern the difference. And that's what those two questions will do, I assure you. They don't like those questions, and I assure you they will probably threaten to arrest you for not participating or some bullshit like that. Anyway, along with that, you'll also see we're entering in a written plea of guilt if they can answer those questions. And then along with that, we're giving them some notes. Those are the notes that you saw in the arraignment thing that I posted here earlier, a few days back. It talks about those two questions, nature and cause. Anyway, so we've got a handwritten plea of guilt that we've got to write up. And then I've got a bunch of other questions that are just going to be handy with us so that we can start shooting them out if they want to give us any problems. We can start. They want to throw distractions. We're going to throw them something to distract them as well. We've got a bunch of other handy questions, as well as the other, I think it was 38 questions that we submitted already as required admissions. So anyway, we'll let you know what goes on after this, one way or another. I'm going to assume that the way they operate, that they're going to push through and try to force him to make a plea, and if he doesn't plea, they're going to practice law from the bench and enter a plea for him. And if they do anything like that, we're going to go ahead and structure our claim and get that filed into the United States Federal Court of Claims. I believe that's it. I've got to do some more final research to make sure exactly which court we're supposed to file in. But it'll be done at the local courthouse, of course, through notice of principal. Notice of principal is notice to agent, and notice to agent is notice of principal. These courts, even though they're foreign to one another, they are still under a certain jurisdiction of the mother corporation. So we have to get to that mother corporation and file a suit against them in our correct court. And that has to be, I believe it's a Article 3 court, and we've got some paperwork on that as well. So we're working on it, and any help we can get from anybody else, we greatly appreciate it. And understand, everybody, this is in no way to be construed as legal advice. We don't do that. We just advise, counsel. And that means passing on news, information, and knowledge. That's all I'm doing. That's all you're doing. Don't let them define what you're doing as well as who you are. Hey, God bless. Love you. Have a great night.